The United States Supreme Court's landmark decision in Gideon versus Wainwright on March 18, 1963, inspired hope that the nation's criminal justice system will provide equal treatment for the poor as well as the rich. Declaring the Constitution requires the government to appoint a lawyer for those who cannot afford one. Gideon laid the groundwork for federal criminal trials, yet states continue to fail to provide independent and well-resourced lawyers. The quality of justice in America continues to depend as much as one's bank account as it does on one's guilt or innocence. People across the United States should be appointed an attorney if they cannot afford one. For example, in Powell versus Alabama in 1932, the United States Supreme Court reversed the convictions of 9 ignorant black men for raping 2 white women on a train to Scottsboro, Alabama. Before 1963, people were not appointed an attorney just because they were poor. That isn't fair, but not appointing a person an attorney because they cannot afford it is unjust.
Do you think everyone is allowed an attorney even if they are wrong for the crimes they committed?
Yes, I think everyone should have the right to an attorney. There were some cases where they were not provided the right to an attorney, and I've seen them.
Yes, because not everyone knows every little scrap of law. That's the job of lawyers. If we don't have that background knowledge, we need someone.
55 years ago, between midnight and 8 o'clock a.m. on June 3, 1961, a burglary occurred at the Bay Harbor Pool Room in Panama City, Florida. An unknown person broke a door there. A witness named Henry Cook reported they had seen Clarence Earl Gideon around 5:30 that morning, leaving with a wine bottle and money in his pockets. Clarence Earl Gideon was charged with the breaking into a pool hall. He could not afford a lawyer to defend him in court, and after a tough trial, he was convicted. If he had accepted his fate, he'd been in prison for 5 years. But Gideon did, however, challenge his conviction all the way to the Supreme Court. When Gideon asked for a lawyer, Louis L. Wainwright, the judge he was held before, explained that the state of Florida only provided an attorney to defendants charged with a criminal that may result in a death penalty. This was the conflict. So Gideon filed a 5-page habeas corpus in January 1962 to the Supreme Court, a habeas corpus petition for release from unjust imprisonment. Gideon claimed that his conviction was unconstitutional because he did not have an attorney to defend himself. The Florida Supreme Court refused his petition, so he took it to the Supreme Court. They reviewed his case and resolved the question of whether or not the right of counsel applies.
What's your opinion on Gideon's actions?
I think he's absolutely 100% correct in this situation. Because he should have had defense. He wasn't guilty, especially. So being wrongfully accused and not understanding the ins and outs of the laws at the time, a lawyer would have been fairly helpful and effective.
Well, his actions were, first of all, I read the case years ago, and the importance of the case is that he said he was innocent. He was in the pool room, but he did not take the coins that he was being accused of. And when they put him in jail, they didn't give him the right to a lawyer.
Louis L. Wainwright was the Secretary of Florida Department of Corrections. He was born on September 11, 1923 in Raleigh, Florida. He went to Nova Southeastern University. He married a woman named Edna Edwards. In the case Gideon versus Wainwright, Wainwright was the respondent of the case. The case was decided by one court in 1962 through 1965. They started arguing in January 15, 1963. The court appointed that the Sixth Amendment allows defendants the right to an attorney, even if charged with serious offense, even if they cannot afford it themselves. It states that in all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. The Supreme Court ruled unanimously in Gideon's favor, a landmark decision on March 18, 1963. A second trial was held in August with a lawyer representing him and bringing out for the jury the weakness in the prosecution's case, Gideon was acquitted. The Best v. Brady case had earlier held that certain circumstances were illiteracy or stupidity of the defendant, or especially complicated case. There was no need for a court-appointed attorney in state court criminal proceedings. Betts had provided optional application of the Sixth Amendment right to the counsel to the states, depending on the circumstances. As Sixth Amendment had only been held federal cases, Gideon v. Wainwright overruled Betts v. Brady, instead holding that the assistance of counsel, if desired by a defendant who could not afford to hire counsel, was a fundamental right under the United States Constitution and essential for a fair trial and due process of law regardless of the circumstances of the case.